She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground, and then had the gall to post another video of it on TikTok. I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement.
Today, we're in Judge Wiggins' courtroom for a case that drew widespread public attention after a violent assault involving a 14-year-old girl. According to prosecutors, the incident was recorded and later shared on social media, where it spread rapidly online. The allegations surrounding the video added another layer of public concern beyond the assault itself. Now, the defendant, Estrella Jones, is appearing before the court for one of her first hearings. Judge Wiggins immediately turns his attention to the seriousness of the allegations and the conditions surrounding the case. At this stage, the court is focused on determining how the case should proceed, not on public opinion or internet attention. Let's see how the hearing unfolds.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned Round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's
no contest, especially for civil liability. I'm cautious to overly allocate for obvious reasons, but what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working in Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the killer. Thank you.
Hans?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of up to 8 years.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that online, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that?
She was 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones, and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that, but I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Oltz, because I had a conflict on that because I was the elected prosecutor when that arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug.
As the hearing continues, both sides present their positions regarding how the case should move forward. The defense argues for a negotiated resolution, while the prosecution emphasizes the seriousness of the allegations and the impact on the victim. Because of the nature of the case, the court decides additional proceedings are necessary before making a final decision. When the matter returns to court, the hearing takes a more emotional turn as the victim's father addresses the court. His statement shifts the focus away from social media and back to the real-world consequences the family says they experienced. Victim impact statements often play an important role during criminal proceedings, giving judges an opportunity to hear directly about the effects of the alleged offense before imposing a sentence.
How is your daughter doing?
She's doing good. I mean, it affected her, but.
How so did it affect her?
just being out, walking around town. She didn't deserve that. She'll get through it.
Okay. Anything else you'd like me to know?
No.
Okay. Thank you for coming today. You can go back out.
One thought that came to mind throughout this case was the saying that hurt people hurt people. I do recall a case where Ms. Jones was a victim of felonious assault, and then it's unfortunate to see her as the perpetrator in this case. My hope with this offer, plea offer, would be that she could be rehabilitated to break that cycle.
Ms. Jones, you had the right to address the court before sentencing. Is there anything you'd like me to know?
I'm very sorry. I never intended to hurt her. I was trauma right now. And I even myself was very shocked seeing the video. And I'd love to get into
You'd love to what? I'm sorry?
anger management classes and more help.
Well, I know you've been through a lot, and I'm familiar in the various roles I've had of the different issues that you've had. And now that you're back on your medications, have things kind of leveled out for you?
It's coming.
And are things going good at your job? The mitigation report describes your peers as saying that they consistently describe you as caring, reliable, and helpful. That certainly wasn't you this particular day, at least as I read in the report. And I don't want you to make a comment on that. But do you understand my concern with putting you on a period of probation that's going to basically allow you to erase your record? Do you understand that concern I have?
Yeah, I understand.
And again, without any comment because of the no contest plea, at least the way the report describes, you went after this girl pretty hard. And it sounds like she had some effect from that based on what her father said. And as I said before, the law is designed to recognize that young people in certain situations do stupid things. Not that I find that this was excusable by any means, or that this was a stupid thing. This was you physically attacking a 14-year-old girl for a comment that was made about somebody else's mother, deceased mother. And then if I recall correctly, there's quote unquote round 2 video for TikTok. Yourself were a victim of a felonious assault. And if I remember correctly, Mr. Carnes, was that the gun being pulled on her?
Yes, sir.
And then you turn around and assault a person who's 5 years younger than you. And you're an adult. She's 14 years old. But at the same time, I realize that you have a struggle aside from this that you need to overcome. And I don't necessarily want to saddle you with anything further. I am a firm believer in allowing people to shape their own destiny, so to speak. So I am going to follow the recommendation. I'm going to put you on a delay of sentence for 12 months. That's the longest period I have available to me. If you're not successful, the conviction stays.
After considering the arguments from both parties, Judge Wiggins decides to impose probation instead of immediate incarceration. The ruling gives the defendant an opportunity to remain in the community under strict supervision while complying with court-ordered conditions. However, the case doesn't end there. According to the court record presented in this hearing, the defendant later returns to court after being accused of violating the conditions of that opportunity through new criminal allegations. At this appearance, the atmosphere is noticeably different as the court evaluates whether the second chance previously granted has been successfully maintained. The hearing highlights an important principle of probation. It offers an opportunity for rehabilitation, but continued compliance is essential to keeping that privilege.
I think I can't do it in the jail. I know I'm 19, but I'm behind, a couple years behind, and I'd like to catch up. And live peacefully and happily and get a better chance at life. I don't want to end up with a year.
I do find that she is still a threat. She went to somebody's house, at least allegedly, to get her earphones and wound up throwing a metal object at that person. I am going to reduce bond to a $5,000 cash surety.
After reviewing the case and the defendant's compliance history, Judge Wiggins issues the court's final ruling. The sentence includes restitution, credit for time already served, and a period of supervised probation with strict conditions moving forward. The judge makes it clear that future compliance will determine whether the defendant successfully completes probation or faces more serious legal consequences. Cases like this often raise difficult questions about accountability, rehabilitation, and when courts should extend additional opportunities for defendants to demonstrate they can follow the law. Now we'd like to hear your thoughts. Do you think probation was the appropriate outcome under these circumstances, or should the court have imposed a different sentence from the beginning? Let us know in the comments below. If you enjoy real courtroom breakdowns, don't forget to like the video, subscribe, and turn on notifications for more real courtroom content. Thanks for watching, and we'll see you in the next one.